A very good evening, dear students. Welcome to BAJIRAO IAS Academy, the Hindu news analysis. So today we have some very important topics for our discussion, and one by one we'll try to discuss these important topics in a very detailed and in-depth manner so that this discussion will be helpful for your examination. And the first very important topic that we are going to discuss is about the issue of stubble burning. And we all knew that the issue of stubble burning is associated with severe levels of pollution in cities like Delhi, and it has also been contributing to the global warming and climate change as well. Now in this context we will understand what are the major reasons for the stubble burning and why the indiscriminate level of stubble burning has been taking place, and what are its impacts on the environment as well as the quality of air, and how can we actually address the problem of stubble burning. And in fact this is very important for your general studies paper 3 of environment and ecology. And what is stubble burning? First of all, we'll try to understand what is a stubble burning. So stubble burning is actually the leftover crop residue that is burnt by the farmers on the field itself before sowing the rabi crop, right? And in fact farmers in northern part of India, particularly in states like Rajasthan, Haryana and UP, what has been happening is that farmers have to prepare their field for the rabi crop immediately after harvesting the kharif crop. However, the time gap is very less to between the harvesting of kharif crops and sowing of the rabi crops. So since the time gap is very less, what farmers would do, instead of taking away all the stubble from the field, farmers just burn the stubble on the field itself. So when farmers burn the stubble, so this stubble burning is a cause of severe air pollution in the northern part of India, particularly in cities like Delhi during the winters, right? So however, why farmers have been adopting this method of stubble burning instead of taking away this stubble out of the field? Why farmers are burning the stubble in the field itself? So we'll try to look into the reasons for that. So we have already understood that the first reason why farmers are burning the stubble in the field itself is that there is a very less time gap between the harvesting and sowing of kharif and rabi crops, and this has been compelling the farmers to burn the crop residue on the field itself. So this is the first reason. And second reason is that burning the crop residue on the field itself is much more cost effective for the farmers than taking away this stubble out of the field manually, right? So the cost effective nature of burning stubble is also another major reason. Since input costs for the farmers have been increasing substantially, so when they burn the field on the field itself, it can also substantially reduce their input costs as well, right? So this is the second reason why farmers are actually burning the stubble on the field itself. And apart from that, there is a lack of alternative for the farmers as well. So alternatives in the sense that, so for example, imagine that when farmers are burning stubble, right? So instead of burning stubble, so if we have an alternative that takes away all the stubble and convert the stubble into pellets, and then this pellets can be used for waste to energy generation. So if such alternatives are available on the field, then this stubble burning can be substantially reduced or it can be prevented. However, since there is a lack of such sustainable alternatives, farmers are burning their stubble on the field itself, and this is the third reason. And the fourth reason is that government has been very often focusing on the high yield crops alone. Now if you look at the MSP regime that the government announces MSP to around 23 crops, and in fact most important crops to which government announces MSP is both wheat and rice. So since the government has been announcing wheat and rice, announcing MSP for wheat and rice, so it actually incentivizes the cultivation of wheat and rice by the farmers. And this is the main reason for the stubble burning, because during the kharif season farmers cultivate rice, and during the rabi season farmers cultivate wheat, right? So apart from that, so once rice is harvested, the climatic conditions which are required, which are suitable for the sowing of wheat, so it actually suits and it also have a very less time. So that's why farmers, instead of carrying away the stubble from the field, they are just burning the stubble on the field itself, right? So apart from that, there are other issues also which are contributing to the stubble burning by the farmers on the field itself. And in fact, it is being said that many farmers have been facing the problem of debt trap or debt burden, right? So this is the one of the major problem that the farming community has been facing, because most of the farmers are small and marginal farmers, and apart from small and marginal farmers, farmers don't have access to the institutional credit. This is the second major problem. And farmers are also not having adequate access to the Kisan credit cards, and because of this particular reason, farmers have been very often relying on the local money lenders. They are very often relying on local money lenders. So since they are relying on the local money lenders, these money lenders have been charging a higher amount of interest rates. So since there are no market reforms and MSP rates are also not that high, and farmers very often facing the financial problems, including the debt trap or the debt burden that the farmers have been facing. There are also instances of farmers committing suicides because of the excess debt as well in states like Andhra Pradesh and Maharashtra. And apart from that, farmers are also getting a less remunerative prices on their produce. So because of these reasons, burning stubble actually reduces their input cost, and it can also save their money and time as well. So this is another most important reason for burning stubble by the farmers on the field itself. And the other thing that we should understand, there is a lack of enforcement mechanism when it comes to the stubble burning. So we all knew that stubble burning is not good for the air quality, because it results in pollution of the existing air. So therefore, there needs to be a strong enforcement mechanism, and this enforcement mechanism can actually prevent stubble burning. But actually at the ground level, there is an absence of strong enforcement mechanism, right? So although stubble burning is penalized, but enforcement of the laws at the ground level are very weak. And in fact, farmers are also very often feel that state does not provide adequate support for the eco-friendly methods. And in fact, farmers are ready to adopt the eco-friendly methods, but there are no alternatives, there is no incentives, and there is no hand-holding support from the state as well. And because of these reasons, it is very often disincentivized for the farmers to manage stubble in an eco-friendly manner. And in fact, so you can also go through the reasons that we have just discussed, that the traditional agricultural practices of over reliance on rice and wheat is the one reason, and the time constraints, farmers have to save the time, and there is a very less gap that is existing between the kharif and rabi crops, and this stubble burning is much more cost effective than managing the stubble by taking it away from the field. And there are lack of viable alternatives, and subsidies and incentives are lacking for the farmers to manage the stubble in a eco-friendly manner. And there is also lack of awareness among the farmers, and there is a poor enforcement mechanism as well at the ground level. So all these factors are together contributing to the stubble burning in India, and stubble burning has been a major cause of air pollution, and it is also contributing to the greenhouse gas emissions or contributing to the global warming as well. But the immediate effect is poor quality of air, particularly in cities like Delhi. Now, in fact, it is also said that India's MSP policy also influencing the stubble burning as well. So as I have already discussed, that the government announces minimum support prices for 23 crops, right? So what is the minimum support price? So this is the price that the government ready to buy the produce from the farmer if market prices goes below this particular price that has been announced by the government. So this is what is called as the minimum support price. So minimum support price is an intervention by the government, and minimum support prices also ensures remunerative pricing. It also ensures remunerative pricing for the farmers as well, right? Now, in fact, it is being said that minimum support price is the reason which has been encouraging monocropping. So how it has been encouraging monocropping? And in fact, generally monocropping is not good for the long-term sustainability of the agriculture sector. So crop diversification has to be promoted to increase the yields. So crop diversification must be promoted or encouraged to promote the yield from different agricultural crops. However, what has been happening, since the government has been providing MSP for around 23 crops, farmers are interested to cultivate these crops which are covered under the MSP rather than cultivating the other crops. So therefore there is a need for the crop diversification which is sustainable, which is climate friendly, and this is also good for the farmers and consumers as well, right? So because of MSP, farmers are preferring to cultivate crops like rice and wheat. So crops like rice and wheat are they are major reason for the stubble burning, and apart from that these crops are also water intensive, and since they are water intensive it has also been contributing to the water scarcity because farmers have been extracting a huge amount of the fresh water, and since they are extracting the huge amount of fresh water, the underground water tables are also getting declined, and in fact farmers are also excessively using fertilizer and pesticides to artificially increase the crop yield. However, in the long term it can lead to the degradation and depletion of the existing natural resources as well. And similarly there are limited efforts to crop diversification, right? So crop diversification has not been taking place because of the MSP that the government has been announcing, and since the government has been announcing, farmers are habituated to cultivate those crops which covered under the MSP, and most importantly wheat and rice over the other crops. So therefore if farmers cultivate any other crop which is not part of the MSP, farmers consider that particular crop as economically unfeasible to switch over to more sustainable crops or more sustainable agricultural practices that could actually reduce the stubble burning as well. And in fact financial constraints also, we have already discussed about these financial constraints, that farmers have been facing the debt burden and they are actually having a higher input cost, but they are getting very less remunerative prices, and this has been encouraging farmers to burn the stubble in the field itself rather than adopting the cost effective methods. And apart from that there is also lack of alternatives to the stubble burning, lack of sustainable alternatives to the stubble burning as well, right? So MSP rates for both wheat and rice have remained stagnant. The government has not increased the MSPs for both rice and wheat since it is stagnant in nature, and it becomes very difficult for the farmers to invest in alternatives to the stubble burning. So since wheat and rice prices have not increased in recent times, it becomes very difficult for the farmers to invest in alternative methods, so that can prevent the stubble burning, or that can result in adopting alternative methods to the stubble burning as well. So therefore the government should also consider increasing prices to both wheat and rice, and also encouraging the farmers to adopt the alternatives to the stubble burning, and also encourage the waste to energy generation as well, and it could also create entrepreneurship in the rural areas as well. So in this context, what needs to be done, or what can be done? So no doubt it actually requires a multi-pronged, a multi-stakeholder approach. Farmers, governments, law enforcement agencies and administration at the grassroots level, gram panchayats and even NGOs for that matter. So number of stakeholders need to come together and they need to work in a collaborative manner, right? So in this context, what needs to be done? So there is a need to create a stubble market. So how can we create this stubble market? So we can actually turn this stubble into something which could be useful. So for that, what we can do, waste to energy. So this method can be adopted. Waste to energy method can be adopted, where this stubble can be sustainably converted into the pellets, and then the pellets can be used for generating energy. And even this stubble can also be used as a fodder to the animals, as well. And in fact, it can also create entrepreneurship and employment opportunities in the rural areas as well. So thereby, here what has been happening, stubble is a source of income, a source of revenue, and also employment for the people in the rural areas and farmers as well. So therefore, when farmers started looking stubble as economically valuable or economically productive, and that's how we can actually reduce the stubble burning and also reduce the amount of air pollution that Indian cities have been experiencing primarily because of the stubble burning, right? So you can also see how stubble burning impact. So it actually result in air pollution because smoke and soot particles, and these smoke and soot particles, they can also deposit on the glaciers, and that can also reduce the albedo of the glaciers. So reducing the albedo of the glaciers means glacier will absorb more and more temperature, more and more heat, and it will lead to the glacial melting and ultimately disappearance of glaciers, and also formation of glacial lake glacial lakes as well in the Himalayas. And apart from that, it is a source of pollution, and it is also source of greenhouse gas emissions, and human health will also be affected by this, right? So there are number of issues which are being associated with the stubble burning. However, stubble burning actually requires sustainable solutions in the long term, so that farmers should look at stubble as economically valuable commodity. And apart from that, there is also a need to strengthen the value chain. So government can actually play an instrumental role in strengthening the value chain for the stubble based products, right? When stubble is being converted into pellets, when stubble is converted into the fodder, and when the government has created a proper supply chain and the market, so this will result in farmers looking at stubble as an economically valuable product. However, this can be done through supporting technologies, storage and processing units, and even transportation. So hence the government can actually play an instrumental role here. And apart from that, government should also initially provide hand-holding support to the entrepreneurs who are coming into this field and also interested in converting the stubble into the pellets and generating energy from the waste of stubble. And similarly, there are alternatives which are available. However, if we don't make these alternatives financially incentivized or financially viable, then it is not possible to explore the alternatives as well. So therefore, subsidies or support mechanisms should make a stubble removal equipment like happy seeders, super straw management systems, so more accessible to small and marginal farmers. Remember, so more than 83% of the farmers are small and marginal farmers. So therefore, there should be sustainable alternatives for the stubble removal, such as equipment including happy seeders and super straw management systems, and they should be made accessible to these small and marginal farmers. And this is also another important way of reducing the stubble burning or preventing this stubble burning on a large scale. And similarly, there is also a need for the market reforms. So market reforms in the sense that there is a need for the remunerative prices for the farmers for various crops. And apart from that, when farmers are getting higher prices for different crops which are not covered under the MSP, it actually incentivizes the farmers to cultivate crops other than those crops which are already included in the MSP. So this benefits the farmers, and this also benefits the existing natural resources through the diversification of the existing crops, and it also prevents the monocropping of the agriculture, and apart from that it can also substantially reduce the incidences of stubble burning in several states as well. So therefore there is a need for appropriate market reforms, and these appropriate market reforms should focus on remunerative prices for the farmers as well. And in fact, you can also see here, the total number of farm fires have been anyway reduced. In 2020, 63,980 farm fires have been reported, but in 2021 it has been declined to 38,078, but still it is a key concern as well. So most of it has been taking place in states like Punjab, Haryana, Rajasthan and Western UP, and stubble burning has been making Delhi a gas chamber during the winters. It has been making Delhi a gas chamber during the winters, and most of it has been taking place during October's and early days of November, right? So these are some reasons why farmers have been resorting to the stubble burning, right? So they lack the machinery, they lack the equipment, and in fact high operation cost, high input cost of removing stubble out of the field, and lack of alternative crops and lack of sustainable alternatives. And apart from that, farmers actually find stubble management lesser rewarding. So all these factors have been compelling the farmers to burn the stubble on the field itself instead of carrying it away from the field. So I hope you have understood this. And the next important topic is judicial overreach and its implications. And in fact, we have already discussed about the recent judgment of the Supreme Court with respect to the powers of the governor when it comes to reserving certain bills, right? So we'll talk about this. So what has been happened is that Tamil Nadu State Governor R.N. Ravi withheld his assent to the bills. So he withheld assent to the bills which are passed by the state legislative assemblies. Now generally in the state legislative assemblies, bills are passed by the assembly and then the bill will be sent to the governor for his or her assent. So governor should give his assent to the bills passed by the state legislative assembly. However, what has been happening here is that governor is appointed by whom? Governor is appointed by the president on the advice of the union government or union council of ministers. President appoints the governor in the state. So here governor is having the dual role as the constitutional authority at the level of state, and he is also the representative of the center in the state level. So therefore he is performing the dual role, and he is also appointed by the union government. So whenever union government appoints governor for the states which are ruled by the opposition political parties, and what has been happening in those opposition political parties, governors are not so cooperative with the democratically elected government in that particular state, and that has been resulting in stalling governance, because Tamil Nadu Governor R.N. Ravi withheld assent to the bills which are passed by the state legislature, and this has led to Tamil Nadu government approach the Supreme Court, and the Supreme Court has said that the governor should not withheld assent to the bills for an indefinite period of time. The governor should give his assent to the bills for a maximum period of 3 months. So within 3 months the governor must give his assent to the bills. The governor should not withheld his assent to the bills for an indefinite period of time. So however, everyone hailed this judgment of the Supreme Court, because it can actually reduce the discretionary power of the governor to withhold the bills which are being passed by the state legislative assemblies, which are democratically elected. But on the other hand, governor, though constitutional authority, he or she is not a democratically elected authority, right? So in this context, I would like to mention Article 200 of the Indian Constitution. Article 200 of the Indian Constitution talks about the options that the governor have when a state legislative assembly passed a bill and presented the bill for the assent of the state governor, right? So the governor have the following options. One, he gives his assent to the bills, and second is he can withhold his assent to the bill, And the third option is that governor can send the bill or return the bill for the reconsideration of the state legislative assembly. And fourth option is governor can actually reserve the bill for the consideration of the president. So he is actually having these four options. Now imagine when a bill is passed and presented to the governor can actually give his assent to the bill, and then the bill will become an act, and governor can also withhold his assent to the bill. However, constitution is largely silent on the time frame within which the governor must give his assent to the bill, and because of that reason several governors are just withhold their assent to the bills which are being passed by the state legislative assembly. And governor can also return the bill for the reconsideration of the state legislative assembly. And in case governor if return the bill for the reconsideration of the state legislative assembly, if state legislative assembly passed the bill with or without amendments, then it is a obligation on the part of the governor to give his assent to the bills. And governor can also reserve certain bills to the consideration of the president as well. However, in this particular judgment, the Supreme Court has held that the president should also take a decision on the bills which are reserved for his consideration within 3 months as well. However, the center has been planning to review this, right? Because constitution is largely silent on this, right? So constitution has not mentioned any specific time frame. Imagine that if the president has not given assent to the bills within 3 months, then the union government must give a valid reasons why it has not given assent to the bills, right? So this is the judgment of the Supreme Court, and in fact many legal experts have seen this judgment as a progressive judgment because it upheld the democratically elected governments or democracy and the independent powers of state legislative assemblies in a federal setup like India and provided by the Indian Constitution, right? So the context is that recently Supreme Court in a particular case, that is a state of Tamil Nadu versus governor of Tamil Nadu case, has invoked Article 142 of the Indian Constitution. So what does Article 142 of the Indian Constitution talks about? So this talks about the power of the Supreme Court to do complete justice in any case. So this is what Article 142 talks about. So it actually gives unlimited powers to the Supreme Court in any matter, and Supreme Court has invoked Article 142 in this particular case. And Supreme Court has also set limits for the gubernatorial assent to the bills, and in fact it has also raised concerns about the judicial overreach and the federal structure that has been existing, right? So how it is going to impact the federal structure that has been provided by the Indian Constitution, and how it amounts to the judicial overreach, not even judicial activism but judicial overreach. Now I would like to tell you what is the judicial overreach. So judicial overreach actually means that the Supreme Court has been intervening in the functions and responsibilities of the executive and the legislature. Supreme Court has been stepping out of its jurisdiction and interfering in the jurisdictions of the executive and legislature is called as the judicial overreach. And in fact Indian Constitution has provided for the separation of powers between the three branches of the government, that is executive, legislature and judiciary. But in this matter Supreme Court has invoked Article 142 of the Constitution, and it has interfered in the jurisdiction, functions and responsibilities of both executive and legislature, and that is why the center has been planning to review this particular judgment of the Supreme Court. So here you need to understand the terms between judicial review, judicial activism and judicial overreach. So what is the judicial overreach? So it is actually means the judiciary oversteps the powers given to it by the Constitution, right? It actually oversteps the powers which are given to it by the Indian Constitution, and in fact it even interfere with the proper functioning of other branches of the government such as executive and the legislature. And one such example is the higher judiciary deciding on Diwali firecrackers banning liquor on highways as well. So these are two examples of judicial overreach. However, what is the example of judicial activism? So judicial activism actually means the proactive nature of judiciary. So whenever the legislature or the executive are not proactive, they are largely silent on some important matters, the judiciary steps in, and judiciary would also take the necessary action to ensure the justice, right? So in fact, one example of the judicial activism is Vishaka guidelines. So Vishaka guidelines on protection of women at the workplaces where there is no legislative enactment in this matter. Judicial activism means that the proactive role played by the judiciary in protection of the right of citizens and promotion of justice in the society. So the example is invented mechanisms which have no constitutional backing, for example suo motu on its own cases, public interest litigation, and new doctrines that are invented by the Supreme Court. And in fact, what is judicial review? So the judicial review actually means the power of the judiciary to examine the constitutionality of legislative enactments and also the executive orders passed by the government, both central and state governments, is what is considered as the judicial review. So therefore, try to understand the difference between judicial review, judicial activism, and judicial overreach as well. So example has been given because Supreme Court has struck down 66A of the IT Act as unconstitutional. This is an example of judicial review because it violates the fundamental rights of the people. So earlier we have discussed about the Supreme Court ruling on the governor's powers as well. So what was that case? That case was the state of Tamil Nadu and also the state governor of Tamil Nadu case. So in this case, the Supreme Court has held that the governor indefinite period of time not giving assent to the bills is considered as illegal and unconstitutional by the Supreme Court, and it has also invoked Article 142 of the Indian Constitution, and that gives unlimited powers to the Supreme Court to do complete justice in any matter. And in fact, the Supreme Court has ruled that the governor of Tamil Nadu, R.N. Ravi, acted illegally by withholding around 10 bills passed by the state legislative assembly. So he, instead of forwarding them to the president or returning them to the reconsideration of the state legislative assembly within the due time. So this is what the Supreme Court has held in that particular case. So this particular ruling has clarified that the limited role that the governor would have in the legislative process, and the Supreme Court also reasserts the primacy of the elected state government in the parliamentary democracy, because the governor is not an elected authority. Governor is an appointed authority, even though he is a constitutional authority here. However, the elected authority is the state government. So therefore, the Supreme Court has given primacy to the elected government in a parliamentary democracy. Now in this context, what the Supreme Court has said in the state of Tamil Nadu versus the governor of Tamil Nadu and ANR case. So we'll try to understand this and then we'll proceed on to discuss how it amounts to the judicial overreach. So how it amounts to the violation of separation of powers as well. So in this particular case, the Supreme Court has held that withholding assent to the bills passed by the state legislative assembly for an indefinite period of time amounts to the unconstitutional act by the governor. And in fact, the Supreme Court has also clearly mentioned that the pocket veto. So pocket veto means that when a bill is passed by the state legislative assembly and presented to the governor for his or her assent, governor is delaying assent for an indefinite period of time, and that is what called as the pocket veto. And what is absolute veto? So absolute veto is a refusal of giving assent to the bill without any valid reason, right? So the court clearly mentioned both pocket veto and absolute veto are not permitted under the Indian Constitution, and therefore this is an illegal or an unconstitutional act by the governor. And in fact, the Supreme Court has also set a clear timelines for the governor and even for that matter president also. And the Supreme Court has said that the governor should take a decision with respect to a bill within 1 month if the governor withhold assent in accordance with the state government's advice. Secondly, the time frame of 3 months has been prescribed by the Supreme Court if governor withholds or reserves the bill against the advice of the state government, and 1 month if the assembly passes the bill again after reconsideration. The governor must give his assent within 1 month. And the Supreme Court also clearly mentioned that if a bill is reserved for the consent of the president, then the president must consider the bill within the 3 months. And on this particular provision, that the center has been planning to review the judgment of the Supreme Court as well. And the article that we are discussing now is also criticism of the Supreme Court's judgment of giving a time frame for such a laws passed by the state legislative assembly. And in fact, the Supreme Court has clearly mentioned that the governor must respect the constitutional convention, and governor should also act as a friend, philosopher and guide to the state government, and he should not be a source of conflict and delay, right? So the role is to facilitate the governance at the level of state rather than delaying the governance deliberately. And in fact, we'll try to understand what exactly is a separation of powers, right? So separation of powers is that we have a different branches of the government, that is executive, legislature and judiciary, and Indian constitution has clearly provided for the separation of powers as well, because the legislative branch of the government would have its own functions, which would have its own jurisdiction. The executive branch would also have its own powers and its own jurisdiction, and similar to the judiciary as well. Now what has been happened, now judiciary has been encroached upon the functions of the legislature as well as the functions of the executive as well, and that is why it amounts to the judicial overreach and not even the judicial activism, right? So when we talk about the separation of powers, it is being said that the ruling of the Supreme Court is considered as the judicial overreach, because this particular ruling of the Supreme Court bypasses Article 200 of the Indian Constitution, Article 201 and Article 74 as well, right? So because these articles earlier not mentioned any specific timeline for the governor and also the president, but this particular ruling of the Supreme Court has been indicating that the Supreme Court has amended the constitution without the real amendment to the constitution, because the Supreme Court has directed the timelines for the assent for both governor and also the president. And apart from that, the author has also been telling us that it amounts to the rewriting of the constitution without any real amendment to the constitution. And in fact, if any amendment to the constitution has to be made, it actually requires parliamentary approval. In certain cases, it also requires the opinion or the consent of the half of the state legislatures. But just by interpreting the laws, just by interpreting the constitution, the Supreme Court has been rewriting the constitution as well. And in fact, courts cannot insert the provisions which require formal constitutional amendments under Article 368 of the Constitution. Article 368 of the Constitution has actually provided for the procedure through which the Constitution has to be amended, but here the Supreme Court itself has been amending the Constitution, and it has also been inserting various provisions to the Constitution as well. So therefore, the legality of it has to be examined. And similarly, the scope of Article 142 of the Indian Constitution has to be questioned, because Article 142 of the Indian Constitution gives unlimited powers to the judiciary to do complete justice, right? But it cannot be used to override express constitutional provisions. However, when we talk about the federalism and states' rights, there is a lack of state representation in this particular case, because this judgment of the Supreme Court would have implications in almost all states, but only in this particular case, Tamil Nadu state government is the only party. So therefore, it also raises questions on the lack of state representation. And apart from that, it can also amount to the excess or centralization of powers by the Supreme Court, and even Supreme Court stepping out of its existing jurisdiction into the other branches of the government, and it is a clear violation of the constitutional provisions, right? So too much judicial overreach would destroy the delicate balance that has been existing among the different branches of the government. And apart from that, it even leads to the distortion of Article 143 of the Indian Constitution, because advising the president is cabinet's prerogative, not judiciary. So here the judiciary has advised the president that the president must take action on the bills which are reserved for his consent by the governor within 3 months. Here judiciary has advised the president but not the cabinet. However, Article 143 of the Indian Constitution clearly mentions that advising president is the cabinet's prerogative but not the judiciary's prerogative. And apart from that, so the judicial process and the accountability of the judiciary, so this judgment of the Supreme Court is also viewed by the experts as violation of Article 145 clause 3 of the Constitution, because the constitutional issues must be heard by the Constitution bench, but this is just a 2-judge bench of the Indian Supreme Court or the Supreme Court of India, right? However, when it comes to the whenever Supreme Court has been dealing with the larger constitutional issues, it has to be decided by the constitutional bench, but the judgment has been delivered by the 2-judge bench of the Supreme Court. Therefore, it also raises the questions on the judicial process as well as the accountability of the judiciary as well. And in fact, there is a chance of legislative retaliation in the sense that the legislation may view this judgment of the Supreme Court as Supreme Court encroaching upon its existing powers, and legislature may pass a constitutional amendment as well. So that constitutional amendment may be against the pronounced judgment of the Supreme Court as well. And in fact, erosion of constitutional majority, because expanding constitutional morality without the textual basis in the sense that, expanding the constitutional morality only by the Supreme Court without doing a physical amendments to the Indian Constitution actually raises a lot of questions over the legitimacy of the Constitution itself, right? So these are the criticisms that are actually raised by the constitutional experts. And in fact, Indian Constitution has provided for the separation of powers. Now, what exactly is the separation of powers? It is the division of legislative, executive and judicial functions of the government among a separate and independent bodies, right? So this is the definition of the separation of powers, and we have legislature, executive and judiciary, and each of them having their own powers and their own functions. And generally it is not expected that one branch of the government encroaching upon the powers and functions of the other branches of the government. So one such example I would like to tell you, that the Supreme Court has declined 99th Constitutional Amendment Act that provides for National Judicial Appointments Commission for the appointment of transfer of judges as unconstitutional, because it has been encroaching upon the independence of the judiciary, and that's why the Supreme Court has declared it as unconstitutional. But on the other hand, Supreme Court has been freely encroaching upon the legislative and executive functions of the or branches of the government. So that's why it may be viewed as something that the Supreme Court has been encroaching upon the powers of other branches of the government. So the next important topic, so this is also a very, very important topic. You may expect a question on this particular topic. So we all knew that the Kuno National Park, which is in Madhya Pradesh, that has been selected as a suitable location for the translocation of cheetahs from Africa to India. So we knew that cheetahs went extinct in India in 1953. So after cheetahs went extinct, Indian ecosystem don't have cheetah population, not even a single cheetah. However, cheetahs are two different types. One is African cheetah, second is Asiatic cheetahs. So Asiatic cheetah population is only found in Iran, nowhere else. But on the other hand, there are African cheetahs as well. So Indian government has signed an agreement with countries like Namibia, South Africa and Botswana to translocate tigers from these countries into the Indian ecosystem. So in fact, the environmentalists have identified, experts have identified that Kuno National Park in Madhya Pradesh is a suitable habitat to translocate these cheetahs into India. So therefore, a series of cheetahs have been brought from African countries and they were introduced in Kuno National Park of Madhya Pradesh. So however, over a period of time, what has been happened is that the Kuno National Park is having excess predators and limited prey. Right? So since it has a limited prey and these cheetahs should also share their habitat with the leopard population, so the scientists have so the experts, the environmental experts or conservation experts have been looking for the other suitable habitat to translocate these cheetahs into, some of these cheetahs into that particular new habitat. However, Gandhi Sagar in the state of Madhya Pradesh, both Kuno and Gandhi Sagar are located in Madhya Pradesh. So Gandhi Sagar is identified as another suitable location for translocating some of cheetahs from the Kuno National Park to the Gandhi Sagar, right? So we'll talk about this as well. In fact, when we talk about this, sorry for that. So actually, when we talk about this earlier, the center government is in talks with countries like Kenya, Botswana and South Africa, and even for that matter Namibia, to translocate the next batch of tigers, next batch of cheetahs to Madhya Pradesh. Right? So we would like to introduce more cheetahs from Africa into Indian ecosystem, right? So this is a part of the cheetah project to ensure that India would have a viable cheetah population. However, this cheetah project steering committee is learned to have cleared the relocation of the sum of cheetahs which are in Kuno National Park as of now to the Gandhi Sagar Wildlife Sanctuary in the state of Madhya Pradesh. And in fact, Project Cheetah Steering Committee advised that the relocation of cheetahs to Gandhi Sagar, although Gandhi Sagar is also located in the same state of Madhya Pradesh, should be carried out with care because of the heat stress and heat wave, because most of the cheetahs have to be moved to the Gandhi Sagar across the road, because Gandhi Sagar is about 300 kilometers from the Kuno Palpur National Park. And in fact, the decision has been taken by the Project Cheetah Steering Committee meeting last week, as concerns linger over the availability of adequate prey. So there is a lack of availability of adequate prey. So if there is a lack of adequate prey, so then it will certainly impact populations of both cheetah and leopard in Kuno National Parks. And in fact, in Kuno National Park, cheetahs are also sharing their habitat with the other predators like leopards as well. So because of the huge competition between cheetahs and leopards, so it will be difficult to maintain the sustained levels of cheetah population in Kuno National Park, and that's why the steering committee has actually taken a decision to shift some of the cheetahs to the Gandhi Sagar Wildlife Sanctuary, right? So this Gandhi Sagar Wildlife Sanctuary has been earmarked as an important link for the long-term conservation of cheetahs, and in fact it can play a very, very important role in the long-term conservation of cheetahs, with an aim to establish a viable population of 60 to 70 cheetahs across both Kuno and Gandhi Sagar landscape. So both Kuno and Gandhi Sagar landscape, so they have spread across Madhya Pradesh and Rajasthan as well. So these sanctuaries have conditions suitable for the cheetah's relocation or introduction. And in fact, the Madhya Pradesh Forest Department has been preparing Gandhi Sagar for the introduction of cheetahs. And in fact, we are about to bring the next batch of cheetahs from African countries. And those next batch of cheetahs will also be introduced into the Gandhi Sagar, wildlife sanctuary. And we'll try to understand about the Project Cheetah. So Project Cheetah is an initiative that has been launched by the government of India to reintroduce cheetahs into the wild. And in India, cheetahs already went extinct in the year 1952 itself. So under Project Cheetah, it actually involves importing cheetahs from the African countries such as South Africa, Namibia, Botswana and Kenya, and establishing them in Indian habitats and suitable Indian habitats within India, particularly the national parks and wildlife sanctuaries, and accord them highest protection and also maintain viable populations of the cheetahs as well. So the goal of Project Cheetah is to restore the ecological balance in the Indian forest ecosystem, promote the biodiversity and also enhance the wildlife tourism and conservation efforts in India. So total we have 20 tigers, so that were brought from Namibia and South Africa, right? So which were introduced in the Kuno Palpur National Park of Madhya Pradesh, right? So the long-term expected population of cheetahs would be around 60 to 70 cheetahs, right? So it is actually the transcontinental relocation project of cheetahs. Now we have already discussed that the phase 1 of the project started in 2022, and the objective of the phase 1 of the Project Cheetah is to restore the population of cheetahs which were declared extinct in the country in 1952. And in fact, the Project Cheetah involves translocation of cheetahs from South Africa, Namibia to the Kuno National Park in Madhya Pradesh. And in fact, this project of translocation of cheetahs is implemented by the National Tiger Conservation Authority in collaboration with Madhya Pradesh Forest Department and Wildlife Institute of India, because the Wildlife Institute of India has the necessary expertise and it can also assist the National Tiger Conservation Authority and Madhya Pradesh Forest Department for the translocation of these cheetah population. So under phase 2, Project India is a project. So India has been considering sourcing cheetahs from Kenya due to the similar habitat existing between India and Kenya. So cheetah will be translocated into Kuno National Park as well as the Gandhi Sagar Wildlife Sanctuary. Both are located in Madhya Pradesh. So when we talk about cheetahs, there are two different varieties of cheetah. One is African cheetah and the other variety is Asian cheetah. So here the IUCN status of African cheetah, it is vulnerable. However, the IUCN status of Asiatic cheetah, it is critically endangered. And Convention on International Trade in Endangered Species status, African cheetah is in Appendix 1 and Asian cheetah is in Appendix 1. And similarly, the distribution of African cheetah in the Southern Africa, Northwestern Africa and also East Africa, but this Asian cheetah's population is mostly limited to Iran. And apart from that, the food intake, so they African cheetah would have a diverse diet due to the bigger habitat that they have, but on the other hand, the Asian cheetah, they have limited sources, medium-sized prey like chinkara, gazelle, etc. Right? The physical characteristics, if you observe the African cheetah, so it is bigger in size as compared to Asiatic cheetah, and it is slightly bigger build and sturdy legs and neck. But on the other hand, the Asian cheetah is slightly smaller, slender than the African cheetah. Their neck is much smaller and slender, and their legs are also slender as well. So these are important characteristics of African cheetah and Asian cheetah, and these are some details with respect to the translocation of the African cheetahs from Kuno National Park to the Gandhi Sagar National Park. So that's all in this lecture, and thank you so much. So if you like our class, please